Welcome to Gnana Deeksha concept-based digital classes for UG colleges. Let me start today's session with a simple question. Have you ever imagined your lives without law? Or did you ever see a society without the existence of law? Absolutely not, because it is so clear that all the activities that we undertake as a part of our daily life are directly and indirectly influenced by law. Now here comes an important question. How many of us are exactly aware of law? What does actually law mean? And how law and society are interrelated? Alright, so you are going to be the perfect audiences for my today's lecture. Today, I am here in front of you to refine your knowledge about the theories of law in a much simpler and interesting manner. So today, I am here in front of you to deal you with the subject business law, which is very important for commerce and management students. In fact, it is important for everyone who are concerned with the business, especially to the new entrepreneurs. By the end of the session, you will be able to learn the definition of law and importance of law in the society, various branches of law, and understand the meaning and sources of business law. Business law, now let us, moving ahead, business law. Business law is absolutely a theoretical paper. So, when it comes to the mindset of students, it is general tendency of students, especially commerce students, that they show more interest towards accountancy part, whereas they lessen their interest when it comes to theoretical papers. So, generally, when we speak about theory can be bifurcated into two types. One is general theory and the other is technical theory. Now, to explain the concept of general theory, let me ask you a question. Now, if I ask a question like, explain the advantages of a partnership firm. X student will say 2 advantages and Y student will say 5 advantages and Z may say more than 10 advantages. Now, if I ask another question like, explain the concept of law of demand. X student will say, when price increases, demand decreases, and when price decreases, demand increases. If I ask Y will say the same. And if I ask Z, the answer would be same. So, are you finding any difference between the first question and the second question? First question was about the advantages of partnership firm, where answers are being varied from person to person, that is from student to student. Whereas in case of law of demand, the answer is same whatever may be the number of students. So, what I meant to say is, in case of general theory, if you are generally aware about the market scenario, you can write as much as possible. But in case of technical theory, it is an observed uniformity. It is having some logical constructions behind it. If you observe here, the subjects like business organization and management, foreign trade, banking and insurance have been written under general theory, wherein if you are generally aware about the market scenario, you will be able to easily write such type of subjects. And coming towards technical theory, I have written business economics in technical side and also business law. Now I hope you got the clear difference between what is general theory and what is technical theory, and how this business law subject is different from all other theoretical papers that you have studied. Now, let us study the deeper insights of law. The word law has been derived from the Teutonic word lag, which means definite. Teutonic is a branch of German language. So, law can be defined as a set of rules and regulations framed by the government of a country to regulate the activities of people in the country. Lord Salmon, an expert in law, has defined law as the body of principles recognized and applied in the state for the administration of justice. Thus, law includes all the rules and principles that regulates our relations with other individuals in the society. So, let us see some of the features of law. As we have already discussed, law is a body of principles developed to regulate all the activities of the people in a country. Law is recognized by the government of the country or parliament. So, here as lawmaking procedure involves the discussions upon a motion. Once the discussions are finalized, the motion will be drafted as a bill. that bill will be forwarded to both the houses, that is Lok Sabha and Rajya Sabha. Once it is approved by both the houses, then it will be sent to President for final assent. If once President gives his assent, the bill will be drafted as an act, and such acts are what we are studying today. And the other feature of law is it is applied in the administration while ruling the country, giving equal justice to everyone. What is the need of law? Law is required in the society to regulate the behavior of individuals and to correspond with what is acceptable by majority of individuals. Law is also needed to establish socio-economic justice and to remove or overcome existing imbalances. Law serves as a vehicle for social change and in turn leads to the development of the nation. Let us have a glance over some of the branches of law. Branches of law. Law is broadly classified into two types. One is national law and the other is international law. National law is again reclassified into civil law and criminal law. Civil law includes constitutional law, administrative law, industrial law, business law, personal and property laws. Let us go in detail with each branch of law. And the first branch of law is national law. National law. The word law, as we have already discussed, is a set of rules and regulations. Now, national law. Nation here relates to a particular country. The meaning of a nation is country. So, national law. The rules and regulations that are applicable to the particular nation and that are to be followed by the citizens of a particular nation is called as national law. So, the laws passed by the government of a country to regulate various activities of the people in a country is called as national law. It applies to all the citizens of the country. National law is also called as domestic law. National law is established by the superlative authority of the nation, that is constitution. Since every country has their own laws, national law differs from one country to another country. These laws are directly and indirectly enforced by the constitution. International law. In contrast to national law, international law is that body where two or more countries come together and frame their own rules and regulations and they follow those rules and regulations. International law is a body of set of rules and regulations that governs the legal relations between or among nations. International law serves as a framework for stable and organized international relationships. These international law principles are approved by various nations of the world. It is the law that regulates how the nations in the world, it is that law that regulates how the nations in the world will interact with each other. It is based on treaties and conventions. International law must be binding on all the members of the nation. Example, WTO. So, WTO is an international organization wherein member countries have come together and framed those rules and regulations and started adopting and using those laws. So, as like WTO, European Union can be cited as a good examples for international bodies. The next branch of national law is civil law. Civil law is that part of national law which shows the rights and duties of the citizens. It shows how a person should live in the country, how an individual should behave with other individuals in the country. Civil law involves conflicts between the people or entities. A civil law case usually begins when one party named plaintiff claims to have been harmed by the actions of other party, defendant, and asks for the relief by filing a suit. So, in case of civil law, there will be usually two parties. One party is plaintiff and the other is defendant. Plaintiff is a person who has suffered loss due to breach of contract, whereas defendant is a person who has committed breach of contract. In other words, we can say plaintiff is the person who files a case upon another person and defendant is the person on whom the case is filed. So, examples of civil law includes cases of divorce, domestic violence, property related cases, etc. Here you can see some of the examples of civil law. The next branch of national law is Criminal law. So the word criminal law itself is indicating that it is related to crimes and illegal activities that are done by individuals. Criminal law is that body of national law that deals with crimes and legal punishments. In criminal cases, the government will prosecute individual for committing an offence. It restricts the citizens of a country from committing crimes and imposes capital punishments for the offenders. So punishments include fines, probations, imprisonment. So in case of civil law, the names of the parties were plaintiff and defendant. Whereas in case of criminal law, the names of the parties would be prosecutor and defendant. Defendant, you can also call them as accused. Examples of criminal law includes murders, theft, assault, illegal use of drugs, etc. All can be cited as good examples of criminal law. So here you can see a clear demarcation between civil law and criminal law. That is, in case of civil law, people will try to settle down the disputes, whereas in case of criminal law, the offenders will be punished. Now let us see the branches of civil law. So that is constitutional law and administrative law. Constitutional law and administrative law are somewhat overlapping to each other because constitutional law is the base for the birth of administrative law. It is through constitutional law that administrative law has come into picture. Constitutional law is an overriding law that establishes principles of government at central and states enacted by elected representatives. It is a body of law that defines the role, powers and structure of different entities within the state, namely the executives, legislature and the judiciary. Constitutional law is considered as a supreme law of India. On the other hand, administrative law deals with the policy making and decision making of government agencies such as tribunals, boards, commissions, etc. It sets out the legal framework within which the public administration is carried out. The next type of law is industrial law. Industrial law, it regulates the relationship between employer and employee, the trade union relationships and the relationship between the industries and government. Industrial law, it relates to the laws that governs industries. These can include a wide range of legal topics ranging from employment laws to environmental laws, laws of contract, industrial relations and worker safety regulations. The primary object of industrial law is to eliminate or put an end to unfair trade practices. The next and important type of civil law is business law. Business law is also called as commercial law or mercantile law. It is that branch of law that comprises laws related to trade, industry and commerce. It mainly deals with formation of business and execution of business contracts. It deals and regulates the relationship between two businessmen of the country and with other individuals of the country. Business law helps to buy, start, operate, manage and to sell the business. It involves right from incorporation to dissolution. So now we have completed with the branches of law. Now let us learn a famous maxim related to law. That is ignorantia juris non excusa. That is ignorance of law is not excused. As per this maxim, every person living in a country, whether they are literates or illiterates, must know the minimum laws which they are concerned with. Although it is not possible for a layman to remember almost all the laws, yet it is very important for us to remember the laws that which we are concerned with. Now let us go into the depth of business law, that is how business law has evolved and what are the various sources from which we have adopted business law and started using it. So evolution of laws. So far we have learnt about the concept of law and various branches of law. Now we should focus more on business law, how the business law has evolved and what are the various sources from where we have adopted this business law and started using it. Evolution of business laws in India. So businesses interact in many and varied ways. Therefore, it is very essential for all of us to refer to the origin and evolution of business laws. Business laws were also there in ancient India in a simpler way. That is, in ancient times, during Indus Valley civilization period, people used to exchange goods and services with other countries in a simpler way like barter system. At this time, they have introduced certain standards like weighing, measuring, etc. As we grew, the complexities in the exchange of goods and services has also increased. As we grew, the complexities in the exchange of goods and services has also increased. And with the arrival of East India Company, the complexities have become more complicated. To overcome these complications or to reduce these complications, the British government has set up certain rules. It has come up with certain rules and regulations, and those rules are called as business laws. The modern business in India started from 1600 AD with the establishment of East India Company. The British Charter conferred corporate character and legal personality to the company and granted power to make laws for its government. This forms the major source of our business law. Now let us discuss some other sources. Here, source means an origin or resource or cause from where the law originates. The term sources has several meanings, but the general meaning of the word source is origin. So here you can see the various sources of business law like English mercantile law, customs and usage of Indian merchants, judicial precedents and statute laws. The first source and the important source of our Indian business law is English mercantile law. Many laws in force in our country are passed by British Parliament during their regime. This English mercantile law is based on two principles, mainly they are common law and the other is principle of equity. Common law here refers to a system of customs and usages that have been followed by British merchants during the ancient times. It is the oldest unwritten law that is based on the practices that have been handed over from generation to generation. The next is principle of equity. Principle of equity lies on the concept of justice and kindness. That is, all the individuals should be treated equally. No favoritism nor no nepotism should be shown to the individuals. It is also the oldest unwritten law. And the next is Statute of British Parliament. When a bill is passed by the Parliament, that becomes a statute. So it is clearly indicating that it is a written law. Equity and common law are unwritten, whereas Statute of British law is the written laws. So those written acts, those written laws which are passed by British Parliament have also become the major source of Indian business law. The next important source of business law is customs and usages of Indian merchants. A number of trade customs and usages familiar with the Indian merchants have been approved and recognized by the law. Now, what actually a custom means? A custom is an activity that have been put into practice since a long time. A custom must be certain, definite, clear and should not be opposed by any public law. Customs play an important role in regulating business transactions. A well-organized custom will override the statute laws. Most of the business customs have been codified and given the legal status in India. Example, Dandupat rule. It is a system of restricting a creditor from collection of more interest rates. That is, in the olden days, money lenders used to give money to the needy people and they used to charge exorbitant rates of interest. To curb such type of activities, the law has set to curb such type of activities, the rule of Dandupat system has come into existence. It has been made a custom of Indian merchants. The next source of business law is judicial precedents. Judicial precedents. The judgments given by various courts are used as rules for giving judgments in lateral cases. That is, for example, a case which has occurred 20 years back what was the judgment which was given in that case would be followed if the same case appears after 20 years. So if required, they used to make some modifications. That is, this system is known as, that is, giving the judgments which were already given in the past for the present cases is called as judicial presidency system. That is, the cases which were decided in England before 1947 and the cases that are decided in India after 1947 are taken as judicial precedents. The next and important source of business law is Indian statute law. So as we have already discussed, a bill, when it is accepted by Parliament, becomes an act. Such acts are called as statutes, which is in written form. After independence, a number of laws has been passed by the Indian government. These all laws constitute a strong source for our Indian business law. Examples: Indian Contract Act, Consumer Protection Act, Environmental Protection Act, Information Technology Act, and so on. So these are the various sources through which our business law has evolved and we started using it. Now, let us study the scope of business law. Scope here includes the broad areas or the broad concepts that are included as a part of, as a subject matter of business law. They are Indian Contract Act 1872, Negotiable Instruments Act 1881, Sale of Goods Act 1930, Partnership Act 1932, Consumer Protection Act 1986, Information Technology Act 2000, and Companies Act 1956 to 2013. So, let us study the gist of each type of act. The first and the major important one is Indian Contract Act 1872. Indian Contract Act 1872 has come into force on 1st September 1872. The law of contracts is the most important branch of mercantile law. It regulates the contractual relations between or among the parties. It is very essential to carry out the transactions related to trade, industry, and commerce. Now, what actually a contract is? A contract is an agreement between two parties which is enforceable by law. An agreement becomes contracts only when it is backed up by the support of law. The scope of business law also includes Negotiable Instruments Act. The Negotiable Instruments Act was passed in the year 1881. Negotiable instrument is a document by which rights vested in the hands of one person. Negotiable instrument is a document by which rights vested in one person can be transferred to other person. It deals with laws relating to three instruments viz. Promissory notes, checks, and bill of exchange. In the current world, business are playing an important role in every aspect of life. Therefore, it is very essential for all of us to learn about the laws, as laws protects both the businessmen and the consumers, and it tries to maintain healthy relationship between the businessman and consumer. Having a general knowledge about the legal principles of law will definitely help a businessman to run his business efficiently. So now let us quickly summarize the key points of today's class. First of all, the word law is derived from the Titanic word lie, which means definite. So, law can be defined as the rules and regulations that are framed by the government of a particular country to regulate activities of people in and around. Law can be classified as two types. One is national law and other is international law. National law is related to the boundaries of a particular country only, whereas international law is where two or more countries come together and make their own rules and regulations. National law is again reclassified into civil law and criminal law. Civil law tells how an individual should behave in the country. It shows the rights and duties of an individual. Whereas in case of criminal law, it shows how an individual should not behave in the country. It restricts a person from committing crime. Civil law includes constitutional law and administrative law. Civil law includes constitutional law and administrative law. Constitutional law is related to making of rules, whereas administrative law is related with the public administration affairs. Industrial law regulates the relationship between employer and employee, trade union relations, and the relationship between the government and the industries. It includes Factories Act, Industrial Disputes Act, Trade Unions Act, etc. Business law. Business law is also called as commercial law or mercantile law. So, the evolution of business law has been started with the establishment of East India Company. East India Company has left an everlasting legacy in the Indian legal system. With the establishment of East India Company, the complexities in the business have been growing, and to overcome these complexities, there have been standardized certain rules and regulations. So, those rules and regulations form the basic source for Indian business law. The various sources of business law are: one is English mercantile law, the other is customs and usage of Indian merchants, judicial precedents, and statutes created by Indian Parliament. Overall, we have learnt a Latin maxim, that is ignorantia juris non excusa. That is, once ignorance of law is not excused under any circumstances. Every person who commits mistake must be punished. No one will be excused under any circumstances. Therefore, we see that laws are affecting the business in numerous ways. So, business law helps to solve all the legal disputes that arises out of business transactions. Business law sets a legal framework for setting up of a business unit, managing the business unit, and to dissolve the business unit. Business law ensures and serves as a way for establishing standards, maintaining orders, settling disputes, and to run the business effectively and efficiently. Business law creates uniformity for the existence of business, that is incorporation, managing, and for the dissolution. Therefore, it is very essential for all the business owners, managers, and other professionals that are directly and indirectly related with the business to know about the rules of business so that they can run their business efficiently and effectively. I hope you all got the concept of business law. So, the study of business law is not only important for commerce and management students, it is also important for everyone who is concerned with the business, and especially for the new entrepreneurs. In the current economic world, business is playing an important role in every aspect of life. Therefore, it is very essential for all of us to study about the laws, as laws protect both the businessmen and consumers and helps to maintain good relations between them. To have a general knowledge about the principles and rules of the business will definitely help the businessman to run his business efficiently and successfully. Interestingly, law can be said as learn, act, and win. That is, learn the rules, put it into actions, and finally you will be the winners. Thank you.